Hello, everybody. First, let me say I'm sorry that I can't personally be there with you today, especially because this is a topic that I find tremendously interesting, timely, and extremely important to our profession. I've always said that I wish I could be in two places at one time, so thank you, Shelley, for making that wish come true today. I'm here to talk to you about technology training, specifically for lawyers, and how it relates to continuing legal education. As I mentioned, I think this is an important subject, and it's something that CLE providers, I think, should be really interested in right now, given the times that we're in and some of the commentary that we've heard recently regarding some rule changes in other states in regards to technology training. I think it's important to give you a little bit of background about where this conversation has come from regarding technology training for lawyers, specifically how it relates to ethics, particularly some concerns maybe that we have in our office that we think that technology training can address, and maybe some ways that we can begin to partner with different organizations in ensuring that lawyers are getting the training that we need. This topic of technology really came about in about 2012. At that time, the then current ABA president, Carolyn Lamb, actually instituted the ABA Ethics Commission 2020. This group was tasked with really looking at our rules of professional responsibility to determine whether or not the rules actually reflected a modern law practice as it is today. And what they determined was that we actually needed to make some changes to our rules, specifically in the area of technology. And so in 2012, the commission proposed several rule changes to the ABA House of Delegates, which passed in the delegates specifically in regards to technology competence. And there we began to look at Model Rule 1.1. Next, a couple of years later, came our Kansas Commission Ethics 2020, which then looked at those rules and made a determination whether or not we needed to actually implement those in Kansas. And of that kind of review of those rule changes, we determined that yes, in Kansas, we needed to adopt some of the changes to Model Rule 1.1 on competence. Out of this suggestion came what we like to call in our office the rule on technology competency. If you take a look at our rule, KRTC 1.1, and specifically if you look at comment 8, you're now going to see some commentary about how lawyers need to stay abreast of the changes in the law and its practice, including the risk and benefits associated specifically to technology. I've been around the state since 2014 when this comment got passed, talking to lawyers specifically about the importance of knowing how to use technology if they were going to implement it in their law office to make sure that they were using the technology ethically. I think I've been around so much for the last 4 years to a lot of your local bar associations and a lot of local areas teaching on technology competence that now there is this interest and there is this hunger by lawyers in our state to actually get this training to ensure that they are adhering to their rules on competency. Thus far to date, about 36 states have actually passed this comment on technology competency. And so what we are also seeing, though, is this question about, well, what does it mean to be technologically competent? And I think that that's important for CLE providers to think about, because I think that that is going to help you in determining what do your programs look like? What should we be teaching lawyers in the state of Kansas? Commentary to this rule has often suggested that it encompasses a lot of different areas. When we talk about technology competency, most often we hear about things like e-discovery or cybersecurity, which are extremely important topics and should be topics that as CLE providers that we're considering whether or not we should be teaching about to our lawyers. But I will tell you that it's more than that. Some of the committee members that were actually on that commission for the ABA that took a look at the rule and were the ones to suggest the rule on technology competency have often said that yes, it includes e-discovery, yes, it includes cybersecurity, but it also includes things like knowing how to use technology in the courtroom, in the boardroom, in the presentation room. It also can include things like how to do internet-based investigations to make sure you're doing your due diligence for your clients. It can also be things just as simple as knowing how to use technology to deliver and leverage your delivery of services to your clients. So for instance, that's things like document assembly, e-filing, file sharing technology. And we often talk about it's even things as simple as Do you really know how to use Microsoft Word so that way you're creating the best electronic brief possible for your client? So these are things to consider, I think, when you are looking at what types of programming that you may want to offer lawyers in your area in regards to technology. After the model rule change was passed in the ABA House of Delegates, the ABA actually issued a resolution, and that was Resolution 106, and that was adopted in 2012, right around the same time that they adopted that model rule change. And in that particular resolution, what they really focused on was urging all states, all continuing legal education regulators to really take a look at their rules and begin to start implementing some requirements, and if not requirements, then some accreditation for these types of program in the area of law practice management and technology. There was a report that went along with that resolution, and there were a bunch of stakeholders that were actually involved in this particular resolution. So you had the Law Practice Management Division of the ABA, the malpractice focus group, several groups played a role. And what they did was they took a look at this report of malpractice claims from the date of about 2008 to 2011. And what they really looked at was what were the main concerns that were coming out of these claims. And what they saw was things like administrative errors, lawyer-client relationship and communication issues, time management issues, things that really related to law practice skills. And so the purpose of the resolution was to actually address those particular issues. They wanted to encourage programming on things like ongoing client communication, client intake, records and file management retention, for instance, things like time, task, deadline management, and then this last one, competent use of systems and technology so that way lawyers could better deliver their services to their clients. Now, in my particular area that I deal with at the Office of the Disciplinary Administrator, myself along with Penny Moylan, who's also here to talk to you today, part of our focus is on our attorney diversion program. And we've recently revamped that to tackle some of these particular issues because we're seeing the same types of issues coming through our disciplinary process. And I think that that's another reason why it's important that as CLE providers, maybe we can partner so that way you can help us in providing this training to lawyers to hopefully keep them out of the disciplinary system. And also partner to give us an option that if we have a lawyer that needs this particular training, we can send them to your organization to ensure that they're getting the training that we need. So we have this rule on competency now that was passed, that was adopted in Kansas in 2014. And since then, we've seen other states adopt a number of different other rules in regards to CLE, for instance. I will say that Kansas was ahead of the curve. When all of this was going on, we had the law practice management credit that was available for CLE providers to provide some of this type of training to lawyers. And we're going to talk a little bit more about Kansas's specific rules, but first I want to talk about some of the recent changes in two other particular states. So for instance, in 2016, Florida was the first state to actually mandate technology training for their lawyers. And what their rule requires is that lawyers need to complete 3 hours of technology training every 3 years of their CLE time period. So that equates to one program a year. North Carolina has recently become the second state to adopt this mandatory technology training. Beginning of this year in 2019, they are actually requiring our lawyers to complete 1 hour of technology training per CLE year. So kind of the same as Florida has done. There are supporters of this, and then there are folks that look at this and ask, is this really enough? So two kind of camps here. So one camp suggests that having the mandatory technology training is great because maybe it gets lawyers that wouldn't have otherwise taken this type of training introduced to it. And the goal and the hope is that once they take their one mandatory class, maybe they will begin to see the benefits of it and begin to take more courses in this particular area. And then you have the other camp that suggests, well, this isn't enough. if we're going to begin to tackle this problem, one course a year isn't going to tackle the bigger issues. Now, I'm not going to mention where I fall into in either of these camps. But what I am going to tell you, as I already mentioned, is that a lot of this training, whether or not here in Kansas we have a mandatory rule or not, you as CLE providers can actually be providing to our lawyers based upon the Kansas rules, specifically in our law practice management area, as well as our ethics programming rules. So if we take a look at the Kansas rules, you will note that lawyers can take up to 2 hours of law practice management programming per compliance year. And in our rules, law practice management programming is defined as specifically designed for attorneys on non-substantive topics that deal with means and methods for enhancing the quality and efficiency of an attorney's service to the attorney's clients. Possible topics that are recommended or suggested under this rule that could be qualified as law practice management programming include issues relating to the development and management of law practice management, including client relations and technology to promote the efficient, economical, and competent delivery of legal services. Now, I just read you those rules to make sure that I had them right. So that way, if I didn't, then maybe Shelley can talk a little bit more about that. But that's what we have on our continuing legal education website as the definition of law practice management, as well as what maybe a qualified program looks like. You might be asking yourself, as a CLE provider, I get it. You know, we have this rule on competency, so it's important that we offer this programming. But how do I get lawyers to this training? I think when I have conversations with CLE providers, with attorneys themselves, the question becomes, you know, how do we convince the masses that this training is important? I know at the end of the day, it's important for CLE providers that you're at least meeting your bottom line, that if you're going to put money into a program, that people will actually show up and attend these programs. So the question becomes, you know, what do we do about that? Especially because if you look at people kind of in my circle that focus on this law office technology realm, a lot of the conversation evolves around the fact that law firms are averse to change, that they're averse to technology, that lawyers need to embrace it but don't necessarily want to. And then this concept of technology is important to lawyers and they don't really understand that it's going to revolutionize the delivery of legal services. So how do we get them there? Well, I think lawyers want the training. It comes down to they just don't know what they don't know. And I think if we can pull them in and get the buy-in, and if we begin to offer programs maybe at our 8-hour days or our 6-hour days, even if it's just one program in this particular area, I think you will find more and more lawyers are interested in it. Now, where's my Kansas Bar Association folks? I know you're here, so I hope you don't mind that I'm going to share this story, but I think this is a prime example of lawyers don't know what they don't know, or they don't know what they need if they don't know that they need it. So just recently, I did a program for the Kansas Bar Association in regards to Microsoft Word training. Really focused in on how do you create a true electronic document or a true electronic brief and some things in the area of security and securing your documents. And it was a step-by-step training. And they had about 20 folks on the webinar. And I was informed that after the webinar was concluded, after they filled out their evaluations of the program, just about everyone on those evaluations said, we want more programming like this. Now they want Adobe training. They want PowerPoint training. So if you can get groups, even if it's just 20 people or 25 people to attend these programs, I think what you're going to see is that they are hungry for it. They do want more of this training. And the hope is that by word of mouth, that they will tell folks in their law firms that they'll go back and they'll say, I went to the CLE providers programming and it was great because I learned X, Y, and Z, and I think the rest of you should attend the next time that they offer this programming. I think we have to take baby steps in getting them to know that and recognize that this training is important, that they really can take something back tangible and significant back to their offices that they can begin to immediately implement with this type of training. Research also suggest, even though that we hear, oh, lawyers are averse to technology, research would suggest that lawyers actually want this particular type of training, and here's why. So if you take a look at the ABA technology report from just this past year of 2018, there was a specific area where they asked questions, technology related questions. One of which they asked was, where does technology training fall in the level of importance for you? And what we begin to see is that about 45% of respondents said that it is actually very important to them. And then about 38% of respondents said that it was at least somewhat important to them. So that was a majority of respondents that say that they think that this type of training is important. So the next question became, well, if you think that this is important, where are you actually receiving your training? And overall, the highest percentage of response was that they're getting it from their IT providers. So think about that for a minute. So 43% said that they're getting this type of training from their IT providers. What do we hear all the time when we begin to do programming for lawyers? What's the first question? Is there CLE credit involved in this? Because they want to tackle two birds with one stone. So if 43% of people are getting it from their IT providers with no accreditation whatsoever, to me, that would suggest if we can offer some accreditation along with this programming, you're going to get lawyers to attend. The other interesting stat from that particular report that I think is of significance to you is that folks were asked, how many of you have training available to you? And 71%, which was a majority of solos, reported that they didn't have any type of training in technology available to them. And firms of attorneys from 2 to about 9 people, about 42% of them indicated that they didn't have training available to them either. So the way that I see this is this is a market area for CLE providers that we need to be looking into if there isn't training available to these particular lawyers. So hopefully now I have convinced you that technology training is important, that there really is a need for it, and that lawyers would want to attend it if you offer that type of programming. So the next question probably becomes, well, what does this even look like then? If I'm going to begin to do this, what do I need to look at? Well, we need to take into consideration our CLE accreditation rules. We need to probably go back to that rule on law practice management. I would suggest you also take a look at the rule on ethics, what qualifies as ethics credit. And then, of course, there's that area of substantive law, which I think we all can kind of immediately define, and we know what it is when we see it. So if we take technology, for instance, like cybersecurity, which is one of my particular favorite topics, that topic can be offered in all 3 different areas. So from a substantive perspective, there are cybersecurity laws out there. There are reporting laws. There's new regulation in the area of cybersecurity. There's the need to understand that if you have a client, maybe it's a business client, how do you advise them, for instance, if they have suffered a data breach? That would very much be substantive law when we begin to talk about those things in advising clients and looking at state laws and statutes and regulations. But we can also offer an ethics portion for cybersecurity. So if we go back to our rule on competency 1.1, and if we go to our rule on confidentiality 1.6, which I will mention in those rule changes in Kansas in 2014 and then the ABA in 2000, prior to that in 2012, they adopted black letter law that specifically goes to cybersecurity practices and the need to prevent the inadvertent disclosure of information. So if we take those 2 rules combined with a couple of others, like, for instance, training and having the responsibility over your staff, the fact that staff has to adhere to the same ethical responsibilities as lawyers have to as well, we can do a whole program on cybersecurity in relations to ethics. What does it look like in regards to our ethical rules? What does it look like putting forth reasonable efforts in order to protect your data so that way you are not suffering from a cybersecurity breach? Then we get into the law practice management area. So maybe we don't talk about ethics at all. And specifically, the only thing that we're talking about, for instance, if we focus on particular software. So if I pull up Microsoft Word, for instance, and I'm doing a course on that, there is a cybersecurity aspect to that. And part of that is showing them specifically how to actually password protect a document, how to remove metadata from their document. So a lot of it is going to be determined upon what does your content look like and what rule does it fall underneath. Another one, for instance, is social media. So there is a substantive aspect to social media, and that substantive aspect includes things like social media evidence. How do we dig for it? How do we obtain it for our clients if maybe opposing counsel is on social media, or a company or a business that's relevant to our cases on social media? How do we go about getting that evidence? How do we go about responding to requests for production per the rules of civil procedure, for instance? All of that would be substantive. But now let's look at the ethical portions of it. We have our rules on advertising, for instance, that are applicable to social media, making sure that we're adhering to those particular rules if we're going to have a Facebook page, if we're going to have a Twitter account, a website with a blog, things of that nature. And then we also have our rules on confidentiality that may be applicable to social media, that lawyers can't go on there talking about their clients and revealing confidential information. So what is the law practice management aspect of social media? Well, that's pretty easy. How do you set up a Twitter account? How do you set up your Facebook page? What does marketing look like on it if we're not going to address the marketing rules and that sort of thing? So a lot of these technology programs, as you'll see, can fit into several different areas. And the reason why I want to bring this to your attention is if somebody feels like they're capped at the 2-hour marker on these particular topics, you can think outside of the box. And you can probably offer them even more training when you begin to look at the content of the program and where does it actually fit for the rules. The one thing to remember, though, when you're doing the ethics programs, remember that it's not just I throw the rules in there and I focus on it for only a couple of minutes and then I move on to the rest of the stuff that I really want to get to, which is really law practice management. There you really have to look at the content and make sure that we are focusing on that ethical aspect of whatever technology it is that you might be talking about. Remember I said that there has been a lot of buzz about Florida and North Carolina, and if you were to actually pull up the rule and look at it, what you'll see is a lot of the things that I have said and I've talked to you like about cybersecurity, about e-discovery, things like that. That's what those rules are really mandating that lawyers really need to know about. So I don't want you as CLE providers to feel hindered by the fact that we don't have mandatory technology training, because you really can be offering this information to lawyers through our rules as they already exist. And I highly, highly encourage that each of you as providers begin to look at this particular area, because I tell you, if you do one, they will come.